at the phone number she had provided spoke to her at 10:20 a.m. and asked her to get a pen and paper to write down the important information. The phone disconnected, and every time that Miss Williams tried to recontact her, it went straight to voicemail, saying that the voicemail was full.
Yes. I'm using a very older Android phone. I'm not working right now, and this is the only phone in the house that I'm able to use. So it did disconnect, and I tried to call back, and I tried to get in contact with Miss Williams, and I could not. I did not know her name was Miss Wendy Williams, so maybe when I was asking the court that I need to speak with probation, they kept directing me to community corrections. I kept telling them that is not who I need to.
Ma'am, you are being directed to where you're supposed to be calling, which is community corrections. So
is that where Miss?
Ma'am, I'm still talking. The last four digits of your number, is it 5694?
Yes, ma'am.
She's been calling that number.
And from which phone number has she been calling? Because the only time that I spoke with her,
I just indicated which number she was calling.
It was a 754 number that cannot be called back in order to contact her. And I did not receive any other calls from that number.
Your Honor.
Spoken with the 31.
Miss Little, please.
3 number and
Miss Little, please stop talking.
Shut up! Shut up! Shut up!
Oh.
Your Honor, I have a number that I can put into the chat. Should she that she can call right now. I was just given that number by Community Corrections. It says that she can leave a voicemail if they are teaching a group and they cannot answer. They did try to call her on 10/27, 10/31, 11/3, and 11/6.
And if you put that in the chat, I am happy to write that down and contact her after to give her that number. That's not a problem. It sounds like there have been some communication issues here, clearly stemming from more our side than anything. So I need to see about rectifying that. If the court would allow, we'd be asking for time to do it.
I will email it directly to you, Jay, so you can give it to her.
Thank you.
Given that there's a pending felony in this case is getting adjourned. The adjournment date will be to November 28th at 10 o'clock a.m. The adjournment will be asked to both the violation of probation. There is also a new charge for failure to stop and identify after a property damage accident. That is the township case. Are you requesting that that be adjourned to the same date and time?
We are, Your Honor.
No objection.
Thank you. Adjourned to November 28th, 2023 at 10 o'clock a.m.
Well, I will receive a notice of that in the mail.
Bond is continued on each matter. Yes, ma'am, it is. You should write it down write it down as well in case something happens with the mail.
Number, you said the 28th?
Yes,
Correct.
the 28th at 10 a.m. And I'll be giving you a call after court.
To speak with the MRT leader, correct?
So that we can discuss everything that we need to.
Okay.
That being one of them.
Let's see everyone back here on November 28th.
I can request that it run concurrent, but whether or not it runs concurrent, that is completely up to parole. Let me ask you this. Have you already been revoked on your parole?
No, ma'am.
All right. Then if you have not been revoked on your parole, then I can say that these state cases will run concurrent with your parole.
Are we off the record?
Yeah, we're not on the
Your
record.
Honor, I have these cases, I owe the state from 2014, 25-year sentence. And, what I was asking as part of the plea bargain is, I'm willing to give the state the conviction if they'll run it concurrent
Oh,
with.
no, here's the thing. This is what I'm telling you. I want you to listen
No,
to me
yes, ma'am.
carefully. I can put in the order that the case will run concurrent with parole. I don't have any jurisdiction over that. I can't force parole to make their case run concurrently with ours. For example, if you had a federal case, I can say, oh, this time is going to run concurrent with whatever they're doing on federal, but I have no jurisdiction to force them to do that. Parole is completely different from probation, but I can put on the judgment that it's to run concurrent with your parole, but I have no jurisdiction to force them to do that.
All I'm asking is if it runs concurrent with one of my case, with my case number that I.
Okay, here's
It is
the
a county case, it is a Bexar County
here's the
case.
thing.
Yes, ma'am.
I know what you want. You know what you want? You want me to tell you
No,
that I can force these cases to run concurrently. That's what you want to hear from me. What I'm telling you is, and I want you to hear what I'm saying.
Yes, ma'am.
I can write on a sheet of paper and say, your cases are to run concurrent with your parole. Guess what? If parole does not want their case to run concurrent with this, it does not have to.
I think it's more of the case. I want to run concurrent with my case, with my active case and not my parole.
These two cases, if their agreement is there to run concurrently, they will be running concurrently.
So,
If you have something that is on parole, I have no jurisdiction to force it to run concurrently. That's what I'm telling you.
as in, I didn't comprehend that part.
Hmm?
I apologize. I didn't comprehend that part.
Yes, I can't force them to do it. I can put in our judgment that these cases are going to run concurrent with your parole, but I can't force parole to run anything concurrent with these cases.
So what happens to, I mean, I'm a little lost right now. What would happen with each case individually?
Individually, if you were going to plead
One
on,
I still 15 years and then I'm getting a 10 with it.
if you were to plead on both of these cases, I can order that these two cases will run concurrent and they will run concurrent. But if you want these two cases, if you're going to plead to these two cases to run concurrent with your parole, I have no jurisdiction over what parole can do. I can put it in judgment and write down these two cases are to run concurrent with your parole. But you know what parole could do? Parole could say, yes, we're revoking him and his parole is not running concurrent.
Well, I'm going back to the Texas Department of Criminal Justice regardless. You know what I mean? I haven't been revoked because we're waiting on the outcome of these cases.
All right, so here's the thing. What I want you to do, we're going to bring you back at 1:30 and I want you to internalize what I'm saying, not what you
No,
want.
yes, ma'am, I understand. I'm just trying to comprehend and break it down how,
I can't break it down any further.
so,
I can't make the parole board run these cases concurrent with your parole. If I put in the motion or I put in the judgment, these cases are to run concurrent with parole, parole could still say, thank you so much, Judge Boyd. We're not running it concurrent.
even if they're Bexar County cases?
Yes, even if they're Bexar County cases. Parole is something completely separate. I have no jurisdiction over the parole authorities.
What if you can run it concurrent with the cases themselves and not parole?
I can say it's running concurrent, but again, parole can still say, we're not running it concurrently. So here's the thing. I know what you want. And we're going to keep saying this same thing. And it's not, my answer is not going to change.
Yes, ma'am.
So come back at 1:30. All right, thank you.
No,
All right, everyone, we're taking our break.
Appreciate that, Judge. Thank you for your assistance.
Thank you, Your Honor.
All right, you're welcome. So we'll be back at 1:30. Yes.
So I believe.
Many unbearable hours later.
All right, court is calling 2024 CR 2324, State of Texas versus Valentin Saldana. Could I have parties announced for the record for the state?
Marjorie Hillman for the state.
Defense?
Your Honor, good afternoon. Frankie Sandoval on behalf of Mr. Saldana.
Are you Mr. Saldana? Counsel, have you received all the discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Saldana, did you review the document entitled True Bill of Indictment with your attorney, and did you understand it? All right, you need to speak up.
No.
All right, counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Your Honor, we are waiving the enhancement paragraph, and we're proceeding on the underlying offense.
Any objection?
No objection, Your Honor.
All right, did you review the document entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Ma'am,
Did you understand you're charged with injury to a child, bodily injury intentionally or knowingly? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand?
yes, ma'am.
All right, you're moving very slow with your answers. All right, do I need to speak up for you?
I think everybody can hear me pretty clearly. Yes, ma'am.
All right. I'm sorry, what?
Yes, ma'am.
Are you understanding everything?
Yes, ma'am.
All right. Did you understand if you have a plea bargain agreement with the state, the court does not have to follow your plea? If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
He has, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
In my opinion, yes, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Saldana, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
No, ma'am.
All right, do you want to go to a jury trial?
If I'm not satisfied with the way I'm being represented, no, ma'am, I don't want to go to trial.
All right. All right, so this is your attorney. This is what I know. We can go off the record. Here's the thing. An attorney will tell you, this is what the state is offering you. You can either accept it or reject it. This is a case that the state has made the decision to waive the habitual. If we were proceeding on the habitual, you know what your minimum is?
Ma'am,
What?
25.
And so you're saying you're not satisfied with your attorney when the state is not proceeding on the habitual.
I'm live. Yes, ma'am, I'm live.
What does that mean?
All right.
All right, we're back on the record. Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, punishment is to be assessed at 10 years in the prison. There are no applications. The state is taking in consideration County Court Cause number 7222472, 2024 CR 3082. There's an affirmative finding of family violence and there's to be no contact with the complainant. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
No.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, ma'am.
Did you understand that to be your plea?
Yes, ma'am.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, it is, Your Honor.
Did you review the paragraph entitled Waiver of Appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
There have not, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Contents.
State, any evidence?
Your Honor, the state offers state's exhibit number 1 and all attachments.
Any objection?
No objection, Your Honor.
Did you review the document entitled Waiver and Consent to Stipulation of Testimony and Stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
No.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
In the interest of justice, that would be our request, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, Mr. Saldana presents himself before you, accepting responsibility for the matter before you. As the court may be aware in reviewing his record.
Excuse me, just 1 second. Mr. Cox, if y'all can move down to the other end, we're on the record. That's okay. All right, we're back on the record. Yes.
Thank you, Your Honor. As the court is aware, Mr. Saldana is currently on parole on a previous case. He would respectfully request, and I make this request on his behalf, that although we understand and he understands not binding, we would ask that the sentence that will be imposed today by this honorable court run concurrently with whatever actions parole takes on his former case.
All right, and what are the parole case numbers?
Your Honor, Mr. Saldana. If I may have a moment, Your Honor.
Sure.
Thank you. The burglary habitation, Your Honor, case out of the 226 District Court, case number 2014 CR 10282B as in boy.
Mhm.
Yes, Your Honor, that's the open parole matter that, again, Mr. Saldana is aware it's not binding, but he would respectfully request this court make a notation that it's the court's desire that it run concurrent.
All right, this court is going to do, as previously stated, the court is finding you guilty. The court will sentence you to 10 years in the prison, give you credit for any time served. There's an affirmative finding of family violence. This will run concurrent with 2014 CR 10282B. Take in consideration County Court Cause number 722472, 2024 CR 3082. There's an affirmative finding of family violence. There's to be no contact with Mallory, Malerie Saldana, Jaden Saldana, Jayden, and Irene Portelis. Is there anything else with regards to sentencing from either side?
Nothing from the state, Your Honor.
Not on behalf of Mr. Saldana, Your Honor, we appreciate the courtesy extended by the court and the state in allowing us to address this matter this afternoon.
All right. And then, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence, and also because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right. Those documents go to the defense attorney. All right, we can go off the record. Your minimum is 25 years in the prison. You understand? Your attorney was able to get you less than the 25 years. Do you understand? And I don't know what you don't understand. It appears that prison is not teaching you what it should be teaching you. But if you come back out and you commit another offense or alleged to have committed another offense, potentially based upon whatever offense that may be, you're looking at a minimum of 25 years. Do you understand? All right, good luck to you.
Thank you, Your Honor.
Thank you.
On behalf of Mr. Saldana, thank you.
All right, thank you.
Thank you. Thanks for me as well.
Yes.